The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Bart Daniel. I'm a former federal prosecutor twice over and also a former state attorney general's white-collar prosecutor. And I've been practicing for many years now. And seated next to me and presenting with me is Jim May, who was early in his career was a assistant public defender. But for the past 10 years, up until just a few months ago, he served as an assistant U.S. attorney. Jim was a federal prosecutor for some 10 years and prosecuted really the most significant case that this district, the District of South Carolina, has ever seen. And that is the criminal prosecution of the Scanner Westinghouse Santee Cooper case. In that case, that is going on, and it's and Jim's left, but the Westinghouse part of the piece of one of their executives was recently indicted, and Jim has handed off that case to another assistant U.S. attorney. So welcome, Jim. The title is, as you see, is What to Do When the Feds Come Knocking. And so the first question you ask is, who would be knocking? And that is the primary players in these investigative agencies. And you see there the FBI. And the OIG is interesting because it can be OIG from most, if you're in the healthcare business, there would be OIG from HHS. However, if you're in the defense contracting business, it would be OIG from the Department of Defense. But also SBA has an OIG arm, as do most of the federal agencies. And then it could be you see the IRS and of course the SEC, and I've got DOD down there. And usually DOD is through their Office of Inspector General. And then EPA and OSHA, which is Health and Safety. And then if you're a state in South Carolina, it would be the Department of Revenue, or more like the Environmental or Safety, DHEC, which is Department of Health and Environmental Control. So those are the players that might become knocking on that door that we're talking about. Next slide, please. So how do you know when an investigation has begun? Well, first off, there may be a potential whistleblower in your midst, either a past employee or worse still, a current employee, so the fox would still be in the henhouse. And you get tipped off usually if it's a past employee from what we call a noisy resignation letter or an exit interview where they tell you, that employee tells you about problems. The noisy resignation letter, of course, is sort of almost self-explanatory, but that would be where they say, I'm leaving this company because I think it's fraught with fraud. And so you have to take that kind of thing seriously as soon as you receive that kind of letter or you hear that kind of allegation at an exit interview. Next would be an administrative demand. Now, administrative demand comes from the U.S. Attorney's Office. It is issued, it comes from the agency. So it could be HHS, but could do it, an administrative demand, or it could be one of the other federal agencies. I think the IRS does some. But the next step up, that more serious, is the civil investigative demand, and that is by the U.S. Attorney's Office. Now, interestingly, that is issued by a civil assistant U.S. attorney. If it's a healthcare or Department of Defense problem, it is usually by their ACE section, which is the Affirmative Civil Enforcement section of the U.S. Attorney's Office. Now, this is when, if you're a client or you're a lawyer that doesn't do these kind of cases that Jim and I do, this is when you start wondering, could there be or is there possibly a criminal investigation? Because in every case involving a whistleblower, Department of Justice has an official policy, and that policy is that while a civil assistant U.S. attorney is assigned as the lead on the case, a criminal AUSA, a criminal prosecutor, will also be assigned to monitor the case. So that's a civil investigative demand. And of course, the next, I guess, more serious is the grand jury subpoena. Now, if you issued a grand jury subpoena to appeal before the grand jury, then you know there is a criminal investigation. Civil investigative demand, there may be a criminal investigation, but a grand jury subpoena, you know there is a federal criminal investigation. And next, if your client or you or your company receives a target or subject letter, and that means simply the letter would say something that would be signed like someone in Jim's former job. It would say, you are the subject or you are the target of a federal grand jury investigation plea involving a violation of healthcare laws or a violation of Department of Justice laws, and you should have your attorney contact me at the number listed below, and of course that's what you would do. And finally, the most invasive and the most serious of all is the execution of a criminal search warrant. And what that tells you is that the U.S. Attorney's Office, Jim May or someone like Jim's successors, has gone to the federal magistrate and told the federal magistrate that A, we believe evidence of a crime exists at this location, and B, due to the exigent circumstances, that evidence may be destroyed or may be done away with or somehow removed. And so we have to obtain a search warrant. We have the need for a search warrant. And that's when you'll hear clients described as a SWAT team of agents. The Gestapo has come and investigating the company. They came in like the Gestapo agents. So finally, so what do you do? I think the first thing you do is you retain qualified counsel. And your next door, your real estate lawyer, or your next door neighbor who's a domestic relations lawyer, divorce lawyer, that's not qualified counsel to help you guide you through the process of a federal or state criminal grand jury investigation. So the first thing is you want to get somebody that knows this particular type of work. And the second thing you'll do is you want to institute what is known as a legal hold or litigation hold. And what that does is it is a deletion prevention policy. And that is you would send a memo or email to all of your employees that would be in a particular group, and you would tell them, do not delete any of the emails. Please save everything. And you would also suspend any automatic deletion if you have a service that does that, or if your system is set up to automatically delete after 60 days or 90 days or whatever the case may be, you would suspend that. And the next thing you would do is your lawyer would contact the assistant U.S. attorney directing the investigation. And we'll talk a little bit more, Jim and I both, about that in a few minutes. And what counsel should do after that counsel's been retained is to meet with the assistant U.S. attorney as soon as possible, because what you want to determine is the nature and scope of the investigation. For instance, is the investigation based on conduct that was limited in nature, or was it contact extreme to the other extreme? Was it systemic in nature? Is it system-wide and throughout? And is it at different locations of the provider, if it's a healthcare provider, or the corporation's offices out in the field? Jim?
So one of the things that you want to do whenever you find yourself in a hole is to stop digging. And the first thing you need to do is make sure that if there's privileged information that is protected. That can be done in various different ways. One of it is to allow outside counsel. Again, Bart said retaining a counsel that knows this business, right? Not the regulatory attorney, not your contract attorney, but people who work in the federal criminal world. You go and hire them, and then they start saying, all right, what would I do as an investigation? Be it the various types of experts or consultants, forensic accountants, to determine what is actually being looked at. The outside counsel then has to be trusted and entrusted that anything that's done internally goes through them. Because what you don't want to have is all of a sudden the general counsel, there's some allegation, there's crime fraud, and therefore that anything that he sends subsequent to the federal agent showing up is considered then crime fraud. By looping in the outside counsel, what you can do is you can protect subsequent remedial measures. You need to make sure that the employees of your client or of your company understand what to do if there's ever an issue. Now, if it is a healthcare provider, and that means CMS showing up, asking for an audit, there need to be various steps to ensure that the appropriate things are done, and that if and when outside counsel is needed, they are brought in immediately. We will talk in a little bit about the PR and PR consultant, as well as what a joint defense agreement looks like in a criminal matter. So when the feds show up, they've likely been investigating your client or your company for months or years. They know more about your company than maybe you do. So the first step that needs to happen, and it should happen in any case of any kind of serious federal investigation, is an internal investigation occurs. What this means is that you need to go through, trace the money, figure out after talking to AUSA what they're looking for. Again, this needs to be conducted by an outside counsel who has the ability, the knowledge, and the experience to not only preserve all applicable privileges, but also to address the concerns that the federal government may have. If there's been an interview of your employees already done, you can't get that bullet back in the gun. Remember Michael Flynn, who for a brief minute was the NSA advisor to President Trump? When the federal FBI agents went to go talk to him, their notes said he confesses great or he lies 1,001. So if there's an interview of you, your employees, or your client's employees, and they provide false information, that is a 5-year felony. So ensuring that you coordinate any kind of statements made by the employees of your client is a very good first step. By talking to the Assistant United States Attorney and cooperating with the agents at the onset, you can also determine the scope of the investigation. Is this a tax investigation? Is this healthcare? Or is it all encompassing to address multiple facets of criminality for your client? Being able to determine the scope of the investigation will help identify what you need to do, how you need to do it, and in what kind of time plan. Developing a plan is about being honest. That's the outside counsel saying, hey, if you just had a search warrant, like, you're in a lot of trouble. And we need to start mitigating the damages. We need to start addressing how to go forward in a productive manner. But developing a plan is a unique circumstance and a unique step that is done in each and every case, and is done only, is only effective when there is truthful and forthright conversations made by internal employees of your client, you, as well as the outside counsel. Preserving documents and electronically stored information, this is the treasure trove that the government's going through. There's a good chance they may have already have seized the vast majority of it. Through search warrants, the government can go and get your email provider, and your client will have no idea that they have done this. So ensuring that you have a document retention system that can adequately go through, as well as can trace if there has been any deletion of evidence. The old saying that, hey, sometimes it's not the crime, but it's the cover-up that's worse, is often true in white-collar cases. If you can show that certain employees of your client have deleted emails, this will be the first thing to show that you are cooperating with the federal investigation. Bart will talk about it in a little bit, but there's something called the Yates Memorandum, which says that your client, the corporation, to not get charged, must fully cooperate with the federal investigation. Now, this is oftentimes a hard conversation to have with the principals. Again, this is about developing a plan that is successful going forward. Once you have preserved the documents, a review of those documents often takes months. Unfortunately, it could sometimes take years, depending on the size and scope of your company. This is one of the things that oftentimes drags on. I know that your client will likely not like the legal bills coming in, but is a necessary step to ensure that everyone knows what occurred. Again, electronic evidence does not disappear. So even if you think that, well, there may be one needle in that haystack, it's worth finding that needle, because sooner or later it will be presented to your client in a meeting with the assistant U.S. attorney as they say, how do you explain this? It's much better to have thought about that. If there is an explanation, it's often found in the other needles in the haystack, and be able to create a chronology of how your client got there, as well as to how to address the concerns that the federal government may have. Bart will talk about in a little bit about the interview with the witnesses. There's a process that has to be taken to protect you and your client. This is not done, it's not intuitive. It is based upon years of case law about what must happen. The open dialogue with the AUSA agents and regulators. If you practice in the civil realm, oftentimes you are nothing besides in a fist fight with your adversary. From start to beginning, you send emails to confirm the communication, and then immediately your adversary says, that's not what I said. That's not the world of federal criminal practice in the District of South Carolina. One reason is that they know that if Bart Daniel says something, The AUSA can take it to the bank. They know that if Jim May says something, they can rely upon it. If I say, I think you have real problems with your cases because of these three areas, it's going to mean something. We're not going to throw hand grenades unless forced to. And in fairness, in a decade, I don't remember anybody who has credibility throwing hand grenades.
No, I agree.
Right. And then
once you throw the hand grenade, you can't get it back, and that's exactly what Jim is saying. It's not. You can remain professional throughout. We always remain professional throughout. We can agree to disagree. Jim and I have tried cases against each other, and at the end of it, we shook hands, and there were no hard feelings because it's no point. There is absolutely no point in getting personal or getting mean-spirited throughout the investigation.
Because once you lose that credibility, then any subsequent client that you have, the AUSA says, well, I remember this one time that you did this. That does not go away. Document the process. This is no different than any other practice of law. So again, developing a plan. This is the key, right? You have to have the principals of your client sit down and understand that they are in real peril. If there is a federal criminal investigation that you know about, that means it's been going on for a time period and there's a substantial amount of evidence that indicates the guilt of your corporation. That's terrifying, right? And to understand that once they've been working on it for 6, 12 months, they're invested. They have beliefs, they have opinions, not that those can't be changed, but that at the onset, it takes some time to get up to speed. If there is illicit conduct, as a healthcare provider, and they're billing a certain code, it is worth addressing immediately. Can we stop that? It's not an admission of guilt, right? Under Federal Rule of Evidence and Stockholm Rule of Evidence 407, subsequent remedial measures are not evidence. But what it does is it shows an attempt to gain compliance as soon as your client finds out there may be an issue. Again, identifying who is the decision maker for your client is oftentimes one of the more difficult, and then once they're identified, controlling them. And when I say controlling them, it's not saying that you force them to do anything, but having client control and having realistic expectation starts from day one. If you, as a regulatory attorney, have a client and you've had this client for years, and he comes to you and says, I mean, this just can't be right. You've looked at everything. Well, you may think you've looked at anything. There may be things out there that you haven't looked at. So managing expectations and saying, hey, what I'm going to do is I'm going to get Bart in here. He's going to take a once over. But what we need to do is we need to be realistic in what he finds is the first step to ensuring that your client has the best chance of going forward and that that corporate client doesn't disappear because you don't know what your client has shared with you or what he hasn't. Documents and electronically stored information. Again, this should be collected by the outside counsel. They will probably work with a third-party vendor, or if they have internal people who can grab and store this information. What happens is that they go and image the server that houses the electronic documentation. They may go and image various cell phones, personal computers. And the whole reason is that they want to be able to look and have a snapshot in time of the first and most recent time they can look and see what has happened in the past. Electronic evidence does not go away, especially with cloud-based servers, text messages. Look at what just happened to John Gruden. Don't write anything, don't have your clients write anything that they don't want to be shown on the front page of the New York Times or the Charleston Post and Courier 7 years later. Looking to determine who may have attorney-client privilege within a corporation, have they consulted with other attorneys outside for a various host of reasons? Is there internal general counsel? Is there a general counsel's office? And trying to be able to segment and segregate the internal attorney-client privilege from things that are clearly not attorney-client privilege is one of the first steps to ensure that there's not actual accidental disclosures. Under Rule 502 of the Federal Rules of Evidence, which does not, this 502 does not exist in South Carolina Rules of Evidence, there is an ability to have a clawback provision. It's something to discuss with attorneys who practice in this unique realm. to make a determination, is it worth providing additional information without waiving privilege to the investigators? But that can only be done after you have a grasp of what that information is. The joint defense agreement is, and Bart's going to talk to you in a little bit about what it means to bring in a team and have a team of attorneys protecting not only your client, the corporation, but also the chief employees who may be in harm's way. But one way to do that and allow for free flow of information is through the joint defense agreement. It's also called a common privilege defense, which allows for free communication between related defendants or related subjects or targets of an investigation. So that way that you can know what, so that way that the corporation can know what the president knew, the president can know what the vice president knew, and you can start putting together pieces to ensure that you can provide and the outside counsel can provide the best representation to your client.
Well, when we started the presentation, I mentioned that the investigation, you may learn of an investigation because of a whistleblower or a noisy resignation letter or an exit interview. And what's happened in the whistleblower world, really, there was no teeth. It was, while it was enacted in 1863 as a civil remedy by the feds for fraudulent claims for payment by munitions dealers, actually, the munitions dealers actually were accused. It was periodically it happened where they would sell to the federal government defective munitions that they knew were defective, they knew were inferior, they were not to grade, but they would sell them to the government and get the money. And there was no, prior to 1863, the federal government had nothing to redress that grievance. 1863, that changed with the False Claims Act. And next slide, please. How about now? It's interesting because later you find out that the False Claims Act looks like it's going to be this perfect tool to sort of police fraudulent activity by contractors for the federal government. But it turns out, when put into practice, that it had no teeth. It had no real enforcement capabilities. So in 1986 was when the great earthquake of a change came. That was actually at the Department of Justice at the time. And the first thing it did is the 1986 amendments lowered the burden of proof from clear and convincing evidence, which is every other fraud case in the civil world, to by a preponderance, or as they say, a greater weight of the evidence. The second thing it did, it's obliterated the ostrich defense. From now on, you can no longer bury your head and say, I just didn't know about that. I didn't see that. I wasn't around during that time. You're still responsible. And then finally, it imposed treble damages, and at the same time, treble damages or triple damages, but at the same time, more than increased the rewards for the relators, 15 to 30% now, which had been relatively low before. So, but later, it got more teeth, if you will, or more bite by the 2009 amendment, which amended the intent requirement. So fraud used to charge, to prove fraud, you had to prove clear and convincing evidence of intent to commit fraud. Now, all of a sudden, that requirement is lessened. It's by a preponderance of the evidence, not just a greater weight, or and it only be, rather than intentional, it only be material to the claim. And so that's the yardstick that the courts use to judge it now. So it's a much lower burden, which of course helps relators and it helps the federal government investigate these cases. In 2010, the Reverse False Claims Act was passed, and what the Reverse False Claim says that you have, if you learn that you've received a payment wrongfully, then you have 60 days to return that payment, or you face civil damages, civil liability. So now, during this broadcast, we're going to mention to you a code word, and that code word is important because in order for all of us to get CLE credits or CPE credits, you need to be able to remember that code word. So you might want to even write it down. And the first code word that I'm going to give you, Jim will give you one later on, is Atlanta. Atlanta, the city, Atlanta, Georgia. Atlanta is the first code word. So now we go to civil and criminal responsibility in investigations. So I mentioned earlier that many investigations begin with the civil investigative demand, so you think for sure it's a civil investigation only, but it may be criminal as well. But with the healthcare world, with the Office of Inspector General and also Department of Defense, they use OIG agents, and it's the same agent that's used in the civil case is also used in the criminal case. So that agent has two roles, civil and criminal, and actually reports and is guided to and teams up with a civil assistant U.S. attorney and or a criminal assistant U.S. attorney. Now, remember I mentioned earlier about the civil investigative demand. It does not foreclose. It does not mean there's not a criminal investigation. And I mentioned that there's a criminal AUSA that's assigned to monitor every case by DOJ policy. Now, there's a great benefit to having counsel, whether Jim May or me or many other good ones in South Carolina, who have a good working relationship with government agents and assistant U.S. attorneys. As Jim mentioned about throwing that hand grenade, you throw that hand grenade one time, or you allege prosecutorial misconduct one time, and that may come up to bite your next client who's totally unknowing about what happened a year or 2 years or maybe even 10 years ago. Because as Jim says, that's one thing federal prosecutors do not forget. They do not, if you breach their trust, if they can no longer trust you, or if you file a prosecutorial misconduct motion that is baseless, because that has great ramifications within the Department of Justice. So you want a good, trusting, working relationship with the assistant U.S. attorneys. And as Jim talked about or touched on earlier, you want to have outside counsel conduct an internal investigation to again determine the nature and the scope of the investigation. Is it systemic or is it limited in nature? Is there an allegation of one wrongdoing or are there many different wrongdoings? So where do you go next if you're counsel? Now, if you're the company, you want to see if there is a criminal investigation, you want to talk with the assistant U.S. attorney. And we both have really good, strong relationships with the U.S. Attorney's Office. And one of the things that we don't even have to ask them if someone else needs separate counsel. But usually when we get an investigation, we'll say, okay, I'm representing the provider, I'm representing the company, I'm representing the contractor, but is there anybody else within the corporation that's in need of separate counsel?
And Bart, I'm sorry for interrupting.
Go right ahead.
But one of the issues about this is that you have what's called the Yates Memorandum. So the Yates Memorandum was made by the Deputy Attorney General. Deputy Attorney General Sally Yates wrote a memorandum that's still in effect for DOJ, which means that the focus of the federal prosecution should be on individuals, not corporations. What does that mean? That means that because individuals make up corporations, that inherently they're going to be the individuals will be looked at for potential criminal liability if it has gotten that far.
Yeah, and they may still look at the corporation, but they don't want to put anybody out. If everybody remembers the failed Arthur Andersen Big 8 accounting firm back then, and Arthur Andersen had 20-some thousand employees around the world, and they were put out of business. And lawyers like myself and Jim were sitting on the sideline saying, these two trains are about to crash. These two trains are about to crash. Someone's got to stop it. Someone's got to blink. And no one blinked. And as a result, Arthur Andersen went completely under, and all those 20-some employees without jobs. And that's one of the reasons why the Department of Justice modified their policy so that corporations, individual employees from companies wouldn't get crushed if the corporation made a mistake. So if you find out if anybody needs separate counsel, you want to also have people, if they're separate counsel, you want to have other counsel who are team players. So what you really would love to happen is if the counsel you retain, you say the CEO or the CFO needs separate counsel, then you would ask your lawyer, you would ask Jim or me or whomever it might be to see if you can recommend counsel that you've worked with in the past or that you know has a good reputation for being somewhat of a team player, always looking out for the client first, always the loyalty is always to the client first, but will otherwise share information in a privileged fashion. And that's where the joint defense agreement comes in. The JDA allows counsel to work together, share protected attorney-client privilege information, and it also allows them to share work product and have that work product maintain the privilege, maintain the protection. As I mentioned, the loyalty to the individual clients All these aspects are spelled out in the joint defense agreement. Now, the joint defense agreement we use, I believe, has gotten 16 additions. We're on our 16th edition, and that's because court rulings came out, and then within individual judges within the District of South Carolina and other districts had made certain rulings. So they told us, you know, that needs to be clear. And you need to clarify that. You should have clarified that in your joint defense agreement. So we've gotten better and better and tightening them up considerably. Now that those different individual counsels, a separate counsel, should coordinate through the company lawyer. So just for one thing, you don't want a duplication of resources. You don't want 5 different lawyers outside reviewing documents. And finally, you don't want any surprises. There's a particular triggering mechanism within the joint defense agreement that if one party does want to leave or exit that agreement and work with the government, all they have to say is, my client is exiting the agreement and I'm returning any work product that the lawyers may have had in the case. Jim?
So we mentioned a little bit about the Yates Memorandum, and one of the requirements for a corporation not to be charged is that it needs to be a good corporate citizen. What does that mean? It means that it needs to be done an internal investigation that highlights and makes a determination as was there wrongdoing? If so, has it been identified? This can't be done by the general counsel. One, the general counsel has rose-colored glasses, possibly, and does not know what to look for. This needs to be done by an outside counsel who is coming in fresh and is looking as an investigator would look at. Again, what you need to do is cooperate in court, or at least coordinate with the federal prosecutor and the agents to focus on what the issues are of the investigation. You need to determine potential exposure. This helps not only advise and manage the expectations of your client, but again, once there's exposure that is identified, then you can start working on how to address it. What you must do if you want to be a good corporate citizen under the Yates Memorandum is you must provide evidence of wrongdoing to the federal government. This is a conversation that needs to happen with outside counsel, any internal counsel, and the client. This is often a difficult conversation, but this is oftentimes what makes is an existential decision for the corporate client. If you don't turn it over, then that corporate client may not exist in 2 years. Again, you need to determine who the key individuals are. In any federal investigation, there are 3 categories of people. Oftentimes, these are good questions to have with your outside counsel. One is a witness. A witness is a person who has evidence of a violation of federal law, yet there is no evidence to suggest that they have broken any federal law. On the other end of the spectrum is what we call targets. A target is not only the focus of a federal investigation, but there's a substantial amount of evidence to indicate guilt. That murky middle is what they call subjects. So be able to quickly identify who is a witness. Witnesses, as Bart was talking about, as far as individual counsel, witnesses sometimes can have what we call pool counsel. A pool counsel is a single firm or individual who comes in and represents several people who do not have criminal exposures. Subjects and targets each need their own counsel. It's not only good for them, but it's also good for the corporation. And again, as we talked about earlier under 407, remedial or corrective actions are not evidence of guilt, but it shows that you are attempting to proceed as a good corporate citizen and to ensure that your client, the company, is working as best it can to address the concerns. So Bart talks about working with the AUSA. The investigators are oftentimes just as important, if not more important, to have a good working relationship. You need to understand who these guys are and these gals. The prosecutors and the agents are individuals who want to serve the government. They want to work for their country, and they want to give up time and money that they could be making elsewhere. Understand that most of them, if not all of them, are trying to get it right. It's something important because you've worked and you've had this client for 20 years and you believe in your heart of hearts they're a good client. But understand that the folks on the other side are not adversaries, as in a civil case. They're not trying to get your money. What they're trying to do is they're trying to get it right. And oftentimes we sit down and we say, all right, hey, if we're wrong, let us know. And that's a conversation you can only have if there's trust, candor, as well as communication. Promptness, there's nothing that drives you crazy that if you've dedicated the last 2 years of your life to a case, the agent has worked maybe 3 years on the case, and you have simple questions from corporate counsel. And those questions, either through email or telephone call, go unanswered for weeks. Because in the federal world, you have a 5-year statute of limitations. Those 5-year statute of limitations oftentimes, in a lot of cases, run up pretty quickly because it's been 2 years since the criminality has occurred. So the federal government finds out about it. It takes a year or two to work up a good financial investigation. So they're sitting there with 12 months. They're run up against the statute of limitations, and they need to make decisions. And the promptness of outside counsel, cooperating with them, trying to come up with the right answer, oftentimes goes a long way in making determinations of should charges be brought, and if so, how should charges be brought. Again, what Bart was talking about is that you cannot retrieve a hand grenade. What we're not talking about is that you are a shill for the government. What we're talking about is that, hey, you now have to know what fights to fight.
Amen.
Not every fight is worth having. This is not civil practice, right? What you're dealing with is you're dealing with the potential of your clients' employees facing loss of their liberty. It's a sobering experience. What they're looking at is putting people in prison. Understanding that and being able to determine which is the right fights, or better yet, if you can resolve anything without a fight. Because oftentimes, the discretion is the better part of valor.
Jim used the contrast of civil business dispute, for instance, and that's what you learn is when you're in this business is you're not, as a defense lawyer, you're not equal to the other side. In a civil case, where you have a dispute between two businesses, you may be equal, right? But in this case, that civil assistant U.S. attorney, even more dire, the criminal AUSA, that person's going to decide, and automatically whether to indict, that is to pull the trigger and indict your client or the client's employees, or not to indict. And so there's no point at all in being uncivil towards that person who is the decision maker. He's your judge and jury, he or she did. They are your judge and jury, at least for a while, until you're indicted. And then after that, only the system takes over, and it's a system of justice, and you do have a federal judge that takes over the case.
And also on that same note, though, and again, it's different between civil. Civil, each side represents the loyalties, and their loyalty only goes to their client. The prosecutor and the agent, they have loyalty to only one thing, and that's to do justice. And oftentimes working and making sure that they are doing the right thing and focused on the right issues, because like all of us, like we sometimes make mistakes, and refocusing on the issues that matter is where the difference between a good criminal defense attorney and a great criminal defense attorney is being able to have those candid conversations with the AUSA, with the agent, saying, guys, I see where you're coming from, but let me show you why I think you got it wrong. Because they don't have quotas, they don't have requirements, and they don't owe anything besides doing the right thing. I know oftentimes we'd walk away from an interview and say, hey, we thought we were about to charge your guy, and he has convinced us not to. Right? Because the only duty we had was to do the right thing. So again, it's a different paradigm than maybe what you're used to in defending your corporate clients. And it's one that, again, is refreshing, because when you have those conversations, if they say that, hey, we can agree to disagree, but I think I'm doing the right thing, like that's one thing that you just have to learn. That's when you just have to go to trial. But that is, that's the very rare exception as opposed to the rule.
Yeah. And so I know clients get frustrated by broad grand jury subpoenas and broad civil investigative demands. And we usually are able to narrow those demands or those subpoenas. But you have to recognize this, as Jim's pointing out, the U.S. Attorney's Office, the AUSAs, and the agents too, they're trying their best to do the right thing. They don't know about your business and how it's run. They don't know about your industry, even if it's a healthcare agent, okay, someone with OIG for HHS. They really know very little about your type of business. There are hundreds of specialties. There are DME companies that have specialties. There are practices that have specialties, and even hospitals, and within hospitals have specialties. And that agent is going to be totally ignorant. And so what we do, what Jim and I and other good counsel do, is we educate them. We find out what they don't understand by having a regular communication, regular contact. And once we find that out, we educate them in putting our client, obviously, in the best possible light. So you talk about interviewing and prepping employees. It's really important to do this early. And really, it's sort of a two-step process. Normally, you would say, ideally, we'll interview the employees, and then later on down the road, when we know more, we'll be able to prep them for an interview should a government agent come knocking. But it's not a bad idea when you first interview the employees or others in the know. It's not a bad idea at all if you go ahead and give them some brief prep points. And one of them would be, if you're contacted by an agent at home in the evening hour, usually during the supper hour, you tell them you're glad to talk to them at a later time, but you want them to go through corporate counsel. You say the name of it. Or if you've got a lawyer, you would say, go through my counsel. And you can decide later on that you may or may not want to submit to an interview, but you don't want to submit to an interview when you're not prepared and when you're just trying to get them away from the house because you want to get back to the supper table, and it's all and you don't want to have to explain to your wife that you got the FBI knocking at your door. So you want to beat investigators to the punch so that they don't, as Jim says, interview the employees first. And many times that's what's already happened. Either the regulator or federal criminal agent has already interviewed some employees or some other witnesses. The next thing is it furthers your internal investigation. I mean, while you're investigating internally, you're gathering information, and that information comes from the interview witnesses. And thirdly, it's the old prepare, and prepare some more. You can't do the more prepared you can do when you conduct the interviews, the better your questions are, and the more information, the more meaningful information you will begin to understand as you go along. So next slide, please. Okay, so we say prepare. So, and this is the hardest part of it. You need to interview employees. You need to have boots on the ground if you're outside counsel right away. But you're going to recognize, you've got to recognize you don't have all of the available information. You have not reviewed all of the available documents, the emails and other things, which could prevent, as Jim refers to, smoking guns. You haven't seen those yet, but you still need to you have to start somewhere. That somewhere is talking with employees. Later on, you can come back and talk to the necessary ones again. You wouldn't go back and interview every employee, but you could go back those key ones that may know something about this email or this piece of evidence that you've come across. You go back and interview, you go back and prep them again. The other thing is you want to be able to understand the documentary evidence. If not, you're going to have, if the counsel doesn't understand it, it's not properly explained to them, you're going to have repeated interviews, or even worse still. And the worst thing you can do is Jim talks about betraying that trust is for Jim or me or someone in our circumstances or what we do, doing what we do is to misinform the assistant U.S. attorney or to misinform an agent when you provide an update. That is one of the most important rules that you want to prevent. You do not want that to happen. So how do you interview witnesses? There are certain rules, as Jim alluded to early in our presentation. And the first thing you do, the first thing I do in every employee interview is what we call an Upjohn warning. And that's the case of Upjohn Pharmaceuticals. And it was involving where an employee gets confused because the employees naturally will think that if you represent the company, you represent that employee. So you've got to set that straight, and you do it in a professional, but sort of somewhat of a gentle manner, but you have to do it. You must do it. You must tell that employee, hey, look, I don't represent you, okay? The privilege is not between you and me. And when you leave here, I'm asking you not to go tell anybody what we've talked about because that would breach the attorney-client privilege. Likewise, if I went out and blabbed to someone outside the company what we talked about today, that too would breach the attorney-client privilege. That privilege doesn't belong to us, doesn't belong to me, it doesn't belong to you as a company employee. It belongs to the company. If that company's 100% owned, it would be to that 100% owner. If it's a board, it would be to the board of directors, but it's not to the individual employees. So you have to make that clear. I'm not your lawyer, but you're just a witness in this thing. And if you need a lawyer at any time, the prosecutor will tell me. I'll from time to time ask the prosecutor if anyone needs their own outside counsel. Because many times they'll ask you that when you're conducting your interview, right? So the witness will understand at the end of that it's not the witness's privilege. So the witness, A, and go out and blab it, but B, isn't relying on corporate counsel, thinking that corporate counsel, that outside counsel, is his or her witness counsel as well. Next slide, please. The Rosenstein memo. It was another deputy attorney general. You've heard about the Yates memo Jim's talked about. There's also the Rosenstein memo, and that is in the Justice Manual, which used to be called the U.S. Attorney's Manual. It is now called the Justice Manual. And the Justice Manual governs the conduct of assistant U.S. attorneys and all Department of Justice lawyers, not just the U.S. Attorney's Office, but all Department of Justice lawyers. So it provides guidance to DOJ lawyers who should target individuals. That's the CEO. Jim talks about targeting individuals within the corporation. And you know the feds, if they start down here, they want to go to the top. If they think the CEO might possibly be responsible, they target or make that CEO the subject. Same with the CFO or any responsible corporate individual. Now, when they target them under the Rosenstein memo, both criminally and civilly. In addition, the Rosenstein memo provides criminal and civil prosecutors the flexibility in dealing with individuals. And now, this is something new, it actually gives you have an opportunity in a civil case, much the way you did in a criminal case, to get cooperation credit. In a criminal case, you have the opportunity for a motion for downward departure for a lighter sentence. In a civil context, you're given credit for cooperation so that you would have to pay, if you actually are responsible, less of a penalty or less of a fine. But this, at the end of the day, this all highlights the importance of having separate counsel. His counsel's duties and responsibilities is my corporate, and me being corporate counsel, me representing the company, or Jim representing the healthcare provider. Does Jim's loyalties and privileges with the CEO? The answer is no. If the CEO, as they say, has the problem or it's the cause of the problem, the loyalty is not ever to the CEO. The loyalty is to the organization, the provider, or the corporation itself. And then you have to have separate counsel for those who may be identified as being in harm's way. Jim?
So, as we all know, that oftentimes the public perception becomes reality. So there needs to be a early consideration of how do you message what's going on with your corporate client. The problem is oftentimes you don't know, right? And once you start having incorrect messaging, that's going to make at least individuals either in the media or in the public start believing that there's something to be hidden. The messaging with public relations, it dovetails very nicely with a very proactive and thorough early internal investigation. This also works with the crisis management plan. Depending on the size of your client, if your client is a large corporation, it's worthwhile to start thinking about what does a crisis management plan look like? What do we do if, and unfortunately, maybe when, we are looked at with some scrutiny by the federal government? The communications with any kind of public relations, though, need to go through outside counsel, so there is a level of privilege going forward. So Bart introduced me and said that when I started out of law school, I was a public defender. The public defender in Richland County was a guy named Doug Strickler. When I walked in that first day, I was ready to go to trial. I thought I was going to be able to beat anybody. And what Doug said was like, you need to sit down. You need to realize the only cases that go to trial in a criminal world are ones where somebody messed up. That may be, the investigator gets the wrong guy, the prosecutor is too draconian, the legislator has made the penalties too harsh. But what we can't have it be is it can't have it be your client or you. So understanding that if there is liability, it needs to be resolved. If there's not liability, or the liability is more civil in nature, then your outside counsel needs to start working with the AUSA and managing the expectations of the investigator to try to avoid a trial. Again, part of this comes with attitude as well as the relationship that your outside counsel has with the decision makers. Again, what happens more than anything else in the federal criminal world is that at least in white collar, you know what happened, right? You have reams of evidence. You have electronic evidence. I can show who said what when. And the question is that criminal? Generally, you can make that determination through a working relationship with the United States Attorney's Office or DOJ components before a trial. Because if there is a trial and there are individuals involved, it is likely going to be a question of, do they go home when the trial is over? Again, this is a different issue. If money's changed in a civil trial, yeah, that's impactful to a person, but it's not that they lose the next 5 years of their life. Again, what needs to happen is there needs to be a sober and clear assessment of where your client, the corporation, or the client, the principal, the owner of the corporation, where individuals fall. So that way a logical and thoughtful assessment can be done that weighs the costs and benefits before there ever has to be a trial. A lot of this can also be avoided in the front end by having a vigorous compliance program. One thing that often compliance programs don't look at, they're run by regulatory attorneys, and regulatory attorneys are great. Bart's firm, as well as my firm, the Wyche firm, have some of the best in the world. However, they look through the world through the Code of Federal Regulations or through the various minutiae that they're used to. What often doesn't happen is it doesn't have people step away and say, well, I see what you're trying to do, but if we look at this, from a 100,000-foot view, what's happening is that the truth's not being told to the public, to regulators, or to other stakeholders, which then can subject your client to criminal liability. Avoiding pitfalls. Again, Bart talked about no surprises and talking about, having a joint defense agreement. No surprises are also where we are here. The one thing I cannot advise of is information and facts that I don't know. And facts are facts. President John Adams said in the Boston Massacre trial, facts are stubborn things. In white collar cases, facts don't change. It's just a matter of their interpretation. Because again, the electronic data, it doesn't go away. So there's going to be facts that cannot be changed. Understanding that and being able to ensure that there is, that your client and the principles of that own your client or that, control your client, that their expectations are managed in the front end, allows you to periodically redefine and reevaluate where the investigation is going. So that way that everybody has at least some sort of understanding of what's going on. Oftentimes this changes. And unfortunately, sometimes it becomes a game of whack-a-mole that, hey, we know this client is bad or this defendant is bad is what sometimes the investigator says. And that's where managing expectations and having the candor to say, Special Agent, I know you've been working on this for 3 years. I just don't think it's there. That's where the candor and credibility of your outside counsel comes into, really pays dividends. Again, this is where we talk about building a rapport. It's critical to establish trust and regular updates with the client as well as with the investigators and the prosecutor. When I was with the U.S. Attorney's Office, I took every defense attorney that I had out for beer because, again, with the U.S. Attorney's Office, we want to know what your client knows, right? We don't want to get it wrong. And I understand that my pronouns are still wrong. I'm 2.5 months out. But the whole idea is to make sure that all the information is going. This isn't a civil trial where you want to have, that one piece of evidence that can sway the jury. You don't want it to ever go to a jury. You don't want your guy to ever, or your client to ever get indicted. Because once a person's indicted, their reputation's harmed. So this is done more on the front end. And a lot of the work in federal criminal cases is front loaded. Because if it does have to go to trial, everything's done already. And then it's just a matter of going in front of 12 strangers.
Yeah, and I would add to that many times the AUSA, the assistant U.S. attorney, and defense counsel really sort of working together. When we have a problem, we find a problem. As Jim says, if it's in an email or if it's in some kind of electronic data, it's embedded there. There's nothing you can do to change that. Well, what you want to do if the company has a problem, you want to do an internal investigation, identify the problem, okay, remedy. Jim said it. Remedial action, remedy the problem. If its conduct is continuing, stop the conduct, and then go to the regulator and say, look, one thing we did find is this, because, ladies and gentlemen, they're going to find it sooner or later. And if they find it versus if you tell them about it, it's a completely different course of action is taken by the assistant U.S. attorney. Jim?
Real quick, your second word to ensure you get CLE credit is one word, go Braves. Gobraves. Go Braves. We need them to beat the Dodgers today.
Okay, let's look sort of, as we wind up, let's look at the federal sentencing guidelines, because when we lawyers look at a case, and an assistant U.S. attorney looks at a case, one of the first things we think about when we first talk to that client, if there's a criminal investigation, we first begin talking to that client. We start thinking out our head, where would this conduct fit within the federal sentencing guidelines? The federal sentencing guidelines, it says, was established in 1991, and that's really when it sort of took off. That the act itself was passed in the end of 1986, taking effect in 1987. But because there were so many guilty pleas, there were white collar cases particularly that are 2 and 3 and 4 and 5 years old. You really didn't start being a tidal wave of enforcement until 1991. The purpose of the federal the federal sentencing guidelines was that defendants across the country with accused of similar crimes should receive similar, not the same, but similar sentences. Here's what the problem was. When I was an assistant U.S. attorney in the 80s, the problem was if I had a drug case that was prosecuted here, Operation Jackpot, for instance, I worked on, that drug case is prosecuted here, a judge gives a 5-year sentence, okay? Because it was, say it was the same amount of marijuana, 100,000 pounds of marijuana. That same amount of hashish or marijuana out in California, they might be given straight probation. Then the second thing that happened is the parole commissions were all regional. And the regional parole commissions in the southern United States were much more severe, much harsher on defendants or now inmates than those parole commissions, particularly on the West Coast, in the Pacific Northwest, in the Pacific Southwest. So you saw that the most important thing the guidelines did was abolish parole, no more parole commission, did away with parole commissions, okay? It abolished parole. That means what time you see is what time you get, is what time you serve, okay? The next thing it does is it requires the judge to sentence the defendants within a narrow guideline range. And if it's below a particular guideline, the government can appeal. If it's sentenced above a guideline, the defendant can appeal. Next slide. They were mandatory. The judge had to do that, right? Had to sentence within that guideline range. That changed in 2005 with Booker versus United States. Judge Clarence Thomas wrote a unanimous opinion by the Supreme Court and said, no, they're not mandatory. They're still constitutional, but they're not constitutional as applied. To make them constitutional as applied, the district court judge must calculate the guidelines, and then he or she must consider those federal sentencing guidelines along with, as advisory, along with the, quote, traditional factors of sentences outlined in Section 18 U.S.C., Title 18 U.S.C. Section 3553. And that's really sort of a summary of the guidelines and the impact and how they really affect our cases, including any client or any individual you've got who may be under criminal investigation. You want to be thinking far ahead, and so you want to make sure that if someone does get prosecuted, they have the lowest possible sentencing guidelines. Jim, we'll close it up.
Sure, and I think one of the things about the guidelines, and so if you are advising a CEO or owner of a company that may have criminal liability, is that in a white collar case, they're a lot more nuanced than the guidelines in a drug case. The drug case has a chart that you can say, if you sell marijuana, this is where you end up. If you sell opioids, this is where you end up. The white collar guidelines are not like that. These are examples that not every white collar case is Bernie Madoff stealing. Some of it may be a lot more nuanced. And bringing in a outside counsel who has the ability to sit down and say, all right, let's think about this a different way. This may not be the correct guideline application. and being able to logically and thoughtfully go through it can mean the difference of, the CEO going home or going to prison for a substantial amount of time.
We want to thank everybody for attending, and I trust everyone's going to get their CLE credit from this. I hope that Jim and I have been able to share some helpful information to you. We didn't intend to try to give you a dissertation on federal or civil criminal liability, but we hope we've helped at least how you would handle the investigative stage should that knock come on your door. Thank you.
Thank you.